This week on the Communicators, a discussion on the passage of new net neutrality rules at the FCC, which would affect how content travels over the Internet. Our guests are Gigi Sohn of the consumer group Public Knowledge and Dean Garfield of the Information Technology Industry Council.
Well, as you can imagine, there was a lot of reaction from all quarters following the FCC's action on net neutrality at their December 21st meeting. And that's our discussion topic on the Communicators this week. First, to kick off our discussion, here's a little bit of FCC Chairman Julius Genachowski discussing the goals of what the FCC did yesterday.
Today we're adopting a set of high-level rules of the road that strikes the right balance between these imperatives. We're adopting a framework that will increase certainty for businesses, investors, and entrepreneurs. In key respects, the interests of edge innovators, the entrepreneurs creating internet content services and applications, their interests, the interests of broadband providers, and of American consumers are aligned. Innovation at the edge catalyzes consumer demand for broadband. Consumer demand spurs private investment and innovation in faster broadband networks, and faster networks sparks ever cooler innovation at the edge. I believe our action today will foster an ongoing cycle of massive investment, innovation, and consumer demand, both at the edge and in the core of broadband networks. Our action will strengthen the Internet job creation engine. Our action will advance our goal of having America's broadband networks be the freest and the fastest in the world.
Well, joining us here on the set is Dean Garfield, who is President and CEO of the Information Technology Industry Council. Mr. Garfield, if you would, tell us what you think of what the FCC did yesterday and tell us about the ITIC.
Thanks for having us here and having me here. I think yesterday's decision on the order was an important step forward in striking a balance between two competing but not conflicting principles. On the one hand, innovation and the transformative potential that we've seen on the internet for innovation, and then two, for investment and bringing certainty so that those who are investing in the internet infrastructure can have some certainty about the regulatory framework and have some assurance on a return on their investment. The members of ITI span the gamut in the information and communications technology sector. We've got 49 members that really are the global leaders in information and communications technology.
Well, Dean Garfield, Meredith Atwell Baker, one of the Republican commissioners, in an op-ed in the Washington Post recently, basically said that what the FCC did yesterday was a solution looking for a problem and that it wasn't necessary.
In general, our members run the gamut in this sector and think that the internet has been an incredibly transformative medium, and that there is a need to ensure that that transformative nature is protected. And so I think it's perfectly appropriate for the FCC to step in and try to set a framework that brings certainty both to consumers and to businesses. And so I don't think it's an overreach. In fact, I think what the chairman did was to try to strike a balance. And striking a balance, you always, to use a colloquialism, you piss people off. But I think the fact that there were people on all sides of this issue who spoke up for and against is suggestive of the fact that it was really striking a balance in a middle road approach, a pragmatic approach.
Well, somebody who is on another side of that issue is Gigi Sohn, who is the president and co-founder of Public Knowledge. Same opening question. What did you think of what the FCC did this week? And tell us about Public Knowledge.
Well, I'll agree with Dean. It was a step forward, but it was not nearly a step forward enough. And to the extent that these rules were supposed to bring regulatory certainty, they will not do that. Because instead of adopting strong, clear rules, the FCC has adopted vague rules and weak rules. And it's not going to lead to certainty. What it's going to lead to is gamesmanship by the telephone and cable companies that provide internet access and who are supposed to be regulated here. It's not going to bring any certainty to the tech sector because until the FCC actually enforces these rules and gets a complaint in front of them and adjudicates and interprets the rules, nobody's really going to know what's going on. We had asked for three very simple changes to the chairman's original proposal. One was to strengthen the wireless rules. Wireless internet access and wireline internet access are treated differently. Wireline is more regulated. Wireless, which is really the future of internet access, particularly for poor people and people of color and rural people, was given less protection. We wanted there to be a presumption against paid prioritization. That being, we don't want the telephone and cable companies to force Google or Yahoo or DirecTV or Dish Network to actually pay for priority service, better quality of service, faster service. We don't want that. There should be a presumption against that. The third thing we wanted was for the FCC to close a loophole that would have allowed broadband internet access providers like telephone and cable companies to provide so-called managed or specialized service. In other words, a service that would give you just the top 20 websites in a way that would evade the open internet rules. So we asked for three very small changes. Unfortunately, the chairman decided not to give them to us, and therefore we're disappointed with the way the rules came out.
What is Public Knowledge?
Public Knowledge is a consumer advocacy organization. We work on broadband policy issues and intellectual property issues, and we seek to protect consumer rights to a democratic and open internet's ecosystem where they have control.
Yeah, I think Gigi's comment speaks to two things. One, the complexities of these issues, and then two, how far we've come in such a limited period of time. I think if we were having this conversation 5 years ago, the list that Gigi went through on the points of disagreement would have been a lot longer. And I think the chairman's statement from yesterday that you heard at the beginning and the order and framework reflects the fact that we're now at a point where we're in agreement on probably 85% of the issues. And this is going to be a continuing conversation. Yesterday's decision and the three commissioners who voted in favor of the order didn't end the conversation, but I think it gave us an opportunity to begin focusing on applying them and continuing to innovate and continuing to get investment in the internet.
Well, again,
do you agree that you're 85% in agreement with?
We've been 85% in agreement with the telephone and cable companies for about 5 years, but it's that 15% which is really, really critical. And the wireless piece is particularly important because, as I said previously, that's the future of the internet. So if
why do you think they were treated differently?
Well, the chairman believes that wireless is a more formative technology and that it deserves more regulatory leeway. And I don't necessarily disagree with him on that point, but I just think he gave them too much regulatory leeway. So one of the exceptions to the net neutrality rules is something called reasonable network management. A network provider should have the ability to manage its network to ensure that it operates efficiently. I don't have any problem with that. And I don't have any problem with giving a wireless carrier more leeway in how it manages its network. But that's not the same thing as saying that a wireless carrier can block applications unless they're Skype or Google Voice, which were clearly in the rules as being prohibited. They cannot block those kind of applications, and it cannot block websites. So those were the two things in the, in the rules. But it's essentially giving carte blanche to the wireless carriers to block things like Sling Media or Netflix, discriminate against them. And that's where we say that's not necessary to give them that kind of leeway. Yes, give them more leeway in how they ensure that their networks run more efficiently, but don't allow them to favor certain applications over others. That's the essence of network neutrality.
I think if you, Gigi, and I sat down today and tried to come up with our own rules around wireless, we could come up with something that is different than what the chairman came up with and likely potentially better. The question is, would that then alienate another whole group of participants in the ecosystem? And certainly it would. And so I think it was smart for the chairman to bank those points of agreement, if you will, and let's fight about the other things over the next 5 years. But let's also focus on other important priorities. In some respects, net neutrality has been like the national debt for the FCC. It's something that's been weighing them down to getting to other important issues. And so I think it was perfectly appropriate for them to say, on wireless, there isn't complete agreement. let's deal with the areas where there are points of agreement and move on.
Well, let's just take a step back here and have you both define what you think net neutrality is and if you think that term should be used. Dean Garfield, we'll start with you.
I think what it really comes down to are the two issues that I talked about at the beginning. So how do you strike a balance between innovation and the ability for anyone to innovate without permission and and on the other side, ensuring a return on investment? In simplest terms, it's how do we ensure that network operators treat any packet, any bit of information that's traversing the network equally and fairly. And I think in figuring out how you treat those packets fairly, in essence neutrally, it's important to try to strike a balance between those two ideas, innovation on one hand and a return on investment on the other.
So to me, network neutrality is about preserving the internet that places control in your hands and my hands. So I don't have to ask permission from any telephone or cable company to see the websites I want to see, to access the applications I want to access. There's no gatekeeper in the middle deciding who the winners and losers are over the internet. Look, we know what broadcasting is like. We know what cable is like. There's a master switch, a master controller in broadcasting that says you can get on my broadcast station, you cannot. Same thing with cable. If I'm an independent programmer, unless the cable operator says I can get on his or her system, I can't do that. And that's what makes the internet so wonderful, is we choose what we want to watch when we want to watch it. There's nobody else choosing for us. And that's what network neutrality maintains, that end user control without anybody making a decision in the middle.
But isn't that the situation today?
It is the situation today for the most part. There have been a half a dozen or so instances that we know about where that hasn't happened, where the network provider has taken control and blocked applications or degraded them in some way, and I can talk about that. But network neutrality is about preserving the open internet we've come to know and love, and which has been this great engine of innovation, creativity, education, civic discourse. That's what we want to preserve. So in some ways, these are prophylactic rules, but as I said before, there have been instances where a network provider has stepped in and said, for whatever reason, I'm not going to allow this application on my network. I'm going to slow down this application.
Yeah, Gigi, I agree with you that it's important to preserve what's good, but we shouldn't preserve it like a dinosaur. The internet is a living thing, and in order for it to continue to flourish, it requires what you've talked about and what I've talked about, the innovative spirit that's really transformed how we live and how we do business. But it also requires investment. And everyone who's looked at this issue says we're going to have a serious problem in the very near term. By 2014, our networks will not be able to handle the traffic that it's seeing today. And so we have to be able to strike the balance between those two competing concerns in some reasonable and rational way. And I think what the FCC did yesterday tries to strike that balance. I don't think you're going to end up with principles that are perfect. No matter what the chairman came up with, it certainly wasn't going to be perfect. But I think in this instance, pragmatism prevailed. And that's a good thing in my mind.
Dean Garfield, what do you think about the divide between wired and wireless?
I think that the wireless and wireline, for some of the reasons that Gigi pointed out, are very different. Wireless is still in a very nascent stage. We have all gotten used to running around with our mobile devices, but that wasn't really the case 10, even 5 years ago. And so those differences should be respected. And so do I think that the FCC could have handled wireless and wireline differently than it did and perhaps improved it in some way? Certainly. But in order to come up with something that strikes a reasonable balance, I think where they ended is a reasonable place. And it's not the end. It's really the beginning of a continuing conversation.
Can we talk about pragmatism for a while, though? Because that's an interesting word that Dean used. And Dean also talked about making sure that the tent was big enough to include not only edge providers and public interest groups, but also wireless carriers and cable operators. And I think the truth needs to be told that the main party that the FCC wanted to keep in the tent was AT&T. They really, really wanted them to stay supportive as possible of this order. But my question is, what did it get them? I don't think it got them very much. because the moment this thing got voted out, the Republicans were saying, we're going to reverse it, we're going to use a Congressional Review Act to reverse it, we're going to have oversight hearings. So I think the chairman was under the mistaken notion that if he keeps AT&T in the tent, that somehow that would tamp down Republican opposition. But if you saw the statements of the Republican commissioners, they were practically goading Congress to overturn this, practically goading them to overturn it. So I don't think he got a whole heck of a lot for keeping AT&T in the tent. And what he got were traditional supporters like my organization saying, we're disappointed. You know, we really could have had full-throated support with modest changes, really modest changes, and he chose AT&T over our organizations. Now, that's his choice. I just don't know if it gets him very much.
Well, you mentioned Congress, and yesterday after the FCC's vote, Senator Kay Bailey Hutchison, who is the ranking Republican on the Senate Commerce Committee, made this statement on the floor of the Senate.
Senator Ensign, who is the ranking member of the Subcommittee on Commerce, I am the ranking member of the Commerce Committee. Together we're going to submit a resolution of disapproval under the Congressional Review Act in an effort to overturn this troubling regulatory overreach by the FCC. I think it is time for Congress to say that we have not delegated this authority to the FCC. The Communications Act, the FCC tried to do this in another part of the Act. They were struck down by the courts. Now they have gone to a different interpretation in a different section of the Act to try to gain the capability to obstruct the freedom of access to the Internet. It is a huge and serious issue that I hope Congress will take the reins and say to the FCC, if we need regulation in this area, Congress will do it.
Dean Garfield.
Yes, sir.
What's your reaction?
My reaction is that it's perfectly appropriate for Congress to exercise oversight in this area, and in fact, to develop long-lasting rules, right? Any administrative agency is subject to the oversight as well as direction from Congress. It's important to keep in mind that a month and a half ago, if that long, there was an effort largely led by then Chairman Waxman to find a resolution to this through congressional action, and they were not able to. And so if in the new Congress they're able to find that resolution, I think it's perfectly appropriate, and many of us would welcome it because it would bring an even greater degree of certainty.
Yeah, I agree. I mean, Congress should act, but it's not going to be able to be easy. I mean, it's something that's going to take a really long time. Look, the internet and broadband, they're in this kind of weird space where cable was probably 40 years ago, where the FCC didn't have direct authority over it. And Congress waited about 20 years to pass the first Cable Act in 1984 and then another one in 1992. So consumers need protection in the interim, and that's why these rules are so important, even though they fall short from in our opinion. But if Congress wants to act, I encourage it to act. I think a lot more things need to be fixed, not just network neutrality. The FCC's legal foundation for doing network neutrality also affects other things that it wants to do. For example, providing universal access to all Americans to broadband, providing subsidies for poor people, ensuring cybersecurity and that public safety can have access, priority access to our broadband system, ensuring that people who use a cell phone can roam, do their broadband internet access in a roaming way like they do with their cell phone service. So there are a lot of things where the FCC's legal foundation for acting to protect consumers are up in the air. So I encourage Congress to act. But in the meantime, the FCC has to.
Well, Gigi Sohn, there's a new Republican House coming in. Fred Upton has already said he's going to have Julius Genachowski at the Energy and Commerce Committee as his first hearing about this. Chances are they're not going to act in the way that you want them to act.
That's possible. We do have also a Democratic Senate. I mean, look, normally these issues have not been partisan. They've been bipartisan issues. It's really only of recent vintage where these have become highly partisan issues. I do think, and Chairman Upton, I think, is a very sensible person. I do think if you get a couple people from each party saying, look, this agency is really in a pickle here. It's trying to twist itself into knots to find the legal authority to do what it needs to do. All of our constituents want broadband, and that's the thing, particularly if you're a rural senator or a House member from a rural area, you want your constituents to have broadband. Right now, it's uncertain whether the FCC can do that under its legal authority.
Well, I want to bring in another voice, and this is Brett Glass, and he is with Lariat ISP in Laramie, Wyoming. Mr. Glass, if you would, tell us about your company and tell us how the FCC's decision yesterday, in your view, affects your company.
Oh, okay. Can you hear me?
We're listening.
Yes. Okay. Lariat, which is the company which I operate here in Laramie, Wyoming, is a rural wireless internet provider. We were the world's first internet provider. We were doing this back in 1992. And one thing that we're concerned about with the regulations is that there was some talk earlier in the program about permission to innovate. If the regulations that the FCC has just passed were in force when we started, we might not have had permission to innovate to do what we want to do. The regulations, we haven't seen all of them yet. We've only got the gist from the staff of the FCC. We're concerned that they would actually outlaw the rate plans which are most popular with our rural customers, which make broadband affordable to the people who get our wireless service. And so we're very worried. We're also very worried about what will happen with investors. A number of investors have backed out of funding us and our attempts to reach even farther into rural areas because they're very concerned about that the FCC regulation will make it infeasible for us to do that. So we haven't seen the final text of the rules yet. As a matter of fact, right now I'm taking a break. I'm actually out installing internet on the roof of a building in a rural area. But we're very concerned about what may happen.
But Mr. Glass, if I could, the FCC yesterday in their vote kept wireline and wireless separate. So would you like to see some regulation on the wireless side?
Actually, what the FCC said that it would do, and again, we don't have the rules in our hands, what the FCC said is that it gave a specific exemption to mobile wireless. In other words, the kind of broadband that you might get on your cell phone. They did not exempt fixed wireless, which is what we do, from the most onerous rules, and that's one of the reasons why we're worried. Wireless is different from wireline. It has more constraints, and in some ways, the wireless which we provide has even greater constraints because we use unlicensed spectrum. We're not large companies which have access to licensed spectrum, which is very expensive to obtain. And as a result, we are hurt even more than the mobile wireless companies are, but we have stricter regulations than them. So we don't believe that the rules as they stand are fair.
There's another voice, Dean Garfield. What did you hear from Mr. Glass?
Actually, very, very little in reality. It's the same point that I made earlier about how far we've come in a relatively short period of time in my mind. I know Gigi disagreed earlier, but we could easily spend another 10 years arguing about the points of disagreement. And what I offer is that we're much better off focusing on the points where we agree, as the FCC did, and then allow, particularly on mobile, the market to continue to develop. And then rather than making decisions based on hypotheticals, let's make decisions based on how the market actually transforms over the next few years. This is truly, it's not the beginning, because we've been debating these issues for over 5 years, but it's certainly not the end.
Gigi Sohn, were you disappointed with Michael Kopp's vote yesterday?
No, absolutely not. Look, something was better than nothing, and I think he feared that if he did not vote yes, the chairman might be willing to actually not vote the item at all, and that we would be left for the next 2 years with no protections at all. So it's a start. It's a step in the right direction, but as we fear, the devil is going to be in the details, and the FCC is going to have to figure out the details on all the critically important questions of what it means to have an open internet. For example, paid prioritization, wireless. The rules are either silent, ambiguous, or actually contradict what we understand to be in the text of the order. The text of the order is supposedly 90 pages long, 80 or 90 pages long.
But nobody's seen it?
Nobody has seen it, no.
The commissioners obviously have,
Right.
but we haven't.
But we knew what the framework they were starting from was the Waxman proposal, which was never introduced because the Republicans wouldn't agree to it. So we kind of knew it was there to begin with. So we weren't starting from zero.
Well, Michael Kopp spoke yesterday, and he was one of the he was the iffy vote at one point. Here's a little bit of what Commissioner Kopp had to say.
There is more that I would have liked in this order. I would have preferred a general ban to discourage broadband providers from engaging in pay for priority, prioritizing the traffic of those with deep pockets who would consign the rest of us to a slower, second-class internet. I also believe we should have done more to strip loopholes from the definition of broadband internet access service to prevent companies falsely claiming they are not broadband companies from slipping through. We made some improvements on the definition, but I still have some worries. I also argued for real parity between fixed and mobile, read wireline and wireless, technologies. After all, the internet is the internet, no matter how you access it. And the millions of citizens going mobile nowadays for their internet and the entrepreneurs creating innovative wireless content, applications, and services should have the same freedoms and protections as those in the wired context.
Gigi Sohn.
Well, I think Michael Kopp's is dead on. These rules fall short in fully protecting consumers. That being said, I think he did the right thing in voting for it. We're going to have to hope that the FCC strongly enforces these rules, and I will thank the FCC for setting up a complaint process where complaints are considered and dealt upon very, very quickly, a so-called rocket docket, and that's good. But my concern is, what about the next FCC and the FCC after that? So these rules are wide open to interpretation, and depending on what your ideology is, they're either going to be interpreted in a way that protects consumers or a way that doesn't.
Well, you're both lawyers, and Commissioner McDowell, the other Republican commissioner on the, along with Meredith Atwell Baker, talked about some of the legal arguments made by this decision.
Despite the desires of some, Congress has not established a new title of the Act to police Internet network management, not even implicitly. The absence of statutory authority is perhaps why members of Congress introduced legislation to give the FCC such powers. In other words, if the Act already gave the Commission the legal tether it seeks, why was legislation needed in the first place? I'm afraid that this leaky ship of an order is attempting to sail through a regulatory fog without the necessary ballast of factual or legal substance. The courts will easily sink it. In another act of legal sleight of hand, the order claims that it does not attempt to classify broadband services as Title II common carrier services. Yet functionally, that is precisely what the majority is attempting to do to Title I information services, Title III licensed wireless services, and Title VI video services by subjecting them to non-discrimination obligations in the absence of a congressional mandate.
Dean Garfield.
There are a lot of metaphors there. I don't know if they all work. Look, he's certainly right that there's a lot of legal uncertainty in this area. And for too long, we've spent a lot of time arguing about process Title I versus Title II. I think we're much better off focusing on what's going to benefit consumers, what's going to benefit innovation, what's going to benefit continued investment in this area, rather than focusing on Title I versus Title II. I could say unequivocally that our members were opposed to Title II reclassification because we live in a world where these services are certainly not exactly the same as your traditional telephony services, and so should be treated differently. That being said, it's time to focus less on process and more on finding solutions that will lead to continued innovation and investment in this area.
So Rob McDowell is quite the drama guy, isn't he? But I actually have to say I agree with at least part of what he said. I think the Title I theory that the FCC has adopted, as far as I know it, and they announced yesterday, is a very leaky ship. And they're going to have a very, very difficult time in court justifying it. We would have preferred that the FCC reverse its decision from 2002 and reclassify Internet Access Service, broadband Internet Access Service, as a Title II telecommunications service. We think that would have been a much firmer legal foundation for this decision. So it's going to be difficult. I think we're going to try to help the FCC support its decision, but I think it's going to be difficult. It will depend on what 3 judges they get, what federal court they go back to. If they go back to the D.C. Circuit, where they lost their authority in April, I think it's going to be a very, very tough slog, and that, you know, if you get the wrong 3 judges, they're going to think that they're trying to evade what this Comcast decision told them to do. If we go to another circuit, which is entirely possible.
You can go circuit shopping in this case.
Absolutely. You can go forum shopping in these cases, and I expect there to be more than one party suing the FCC, and probably some parties that we're friendly with as well, because we didn't get everything we wanted.
Now, how quickly do you see this coming to court?
Well, it depends on when the FCC's rules are actually issued and when they're actually in the Federal Register. I believe we've got 30 days after that to appeal. Some parties may seek reconsideration by the FCC itself, so it can actually go back to the FCC if people want to do that. I don't know why they would do that. I don't think that this carefully carved compromise, there's any wiggle room to change that very much. But I believe it's about either 30 or 60 days, excuse my memory, after the order is published in the Federal Register that folks can start to go to various and sundry courts to get this appealed.
The courts are certainly not a short-term solution to this. And so I think what's likely to happen more quickly is Congress getting engaged, which, as Gigi mentioned earlier, I completely agree with that. The one thing that I would add is that, you know, in addition to focusing on this issue of net neutrality, I think we both agree that we need to do something about universal service, and certainly we need to do something about spectrum, particularly spectrum on the mobile side. There's legislation that's percolating in Congress now around spectrum that I think has bipartisan agreement, and I would strongly encourage, before getting too bogged down in net neutrality, we deal with that issue where there's 100% agreement.
Dean Garfield, your group, the Information Technology Industry Council, back in August, according to news reports, was the host at some of these side meetings that were being held between Google and Verizon and some other activist groups, internet groups. Did what came out of the FCC yesterday reflect your discussions back in August? It
did, but it reflected a evolved version of our discussion. Those discussions took place in the summer. They were subsequently followed up by additional discussion with then Chairman Waxman. Then the process moved to the one that finally resulted in the document, the order, and framework that we saw yesterday. And so, yes, it was a part of the process, but certainly not the end.
Did you invite Gigi Sohn to those discussions?
You did.
We did, yeah. And so, the thing that we thought, which I think Gigi will agree with, and she actually made this point earlier, is that, you know, the points of agreement became clear and may have been clear for quite some period of time. And so, rather than continue to have a debate where it appeared to be big business versus small business, public interest versus corporation, Gigi and I both agreed it would be useful to get folks in a room and start talking about where do we agree and where can we reach some resolution and a roadmap for moving forward.
Yeah, Chairman Waxman's legislative proposal really sort of was the baseline here. But the problem was it was really only supposed to be a baseline, and he and his staff was very clear that it was supposed to be the floor and not the ceiling. Unfortunately, I think that it was more the ceiling than the floor. Yes, some minor changes were made. A complaint process was put in there, which is very, very important. But it didn't go as far as we would have liked it. But really, the Waxman process really kicked things off. There were not only ITI meetings, but there were also meetings facilitated by the FCC, which we were not a part of. The Open Internet Coalition, which we are a member of, was part of. Those blew apart after Verizon and Google came out with their agreement, which was roundly criticized from just about everywhere, and nobody was defending that. So those really didn't have as much impact. But really the Waxman, you know, the power of Henry Waxman bringing people together in a room and saying, look, we've got to do something here. really was what got it started. I just wish it hadn't ended there. I wish it had gone a little bit further.
Well, the discussion continues here on the Communicators as well. Thank you for being on here to discuss net neutrality.